Next matter to come before the court this morning is State of Ohio ex-rel Kristy Stoicouiu versus Stow-Munroe Falls City School District. Both sides will have 15 minutes to present oral argument. If you're the appellant and wish to, you may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'm keeping track of the clock. It's also posted on the wall over there. The arguments are being recorded, so please keep your voice up or remain behind the podium. Please don't use the names of any minors, children, victims. I'm not sure that's at all relevant to this appeal, but we like to make that advisement since the recorded arguments are posted on the internet. We have read your briefs. We're ready to proceed when you are.
Good morning, and may it please the court. Zach Morrison on behalf of the plaintiff appellant Stoicouiu. In this case, Ms. Stoicouiu filed a verified complaint alleging whistleblower status and retaliation associated with her public reporting of fraud and abuse within the Stow-Munroe school system. The fraud and abuse involved illegal gifts, expenditures, and falsified payroll records by the superintendent and his personal assistant. The fraudulent scheme was implemented approximately 5 years before Stoicouiu became treasurer. However, it was discovered by Stoicouiu during her tenure as treasurer. Once Stoicouiu discovered the fraud and abuse, she made a public reporting to the state auditor, and she reported it to the school board.
Counsel, let me just ask you, because the school district says that there's nothing in the record to demonstrate, and I'm not sure that this is dispositive in any way, shape, manner, or form, but there was no evidence submitted that she did, in fact, make a direct report to the state auditor.
Your Honor, there is evidence in the record. The evidence in the record is the testimony of Stoicouiu herself. And I would acknowledge and concede that that is a disputed factual issue. Stoicouiu said she reported it. The board president, however, claimed that she had reported it. In any event, once it was reported, the auditor conducted an investigation and found that both the superintendent and his personal assistant had engaged in fraud and abuse, and there was a finding for recovery against both of those individuals. At the time Stoicouiu reported the matter to the auditor of state, then president of the board was critical of Stoicouiu for making a referral to the auditor. She was upset that Stoicouiu had made the matter public by reporting it. Within about 120 days after having reported the fraud and abuse, Stoicouiu lost her contract as a treasurer through a non-renewal process. While the perpetrators of the fraud and abuse, the superintendent and his personal assistant, were retained and in fact received raises. Prior to Stoicouiu discovering and publicly reporting the fraud and abuse, she had an unimpeachable record with the Stow-Munroe School. She had been there 8 years. She received the highest marks, accolades, and positive performance evaluation in the past. Against this backdrop, the whistleblower's status was alleged by Stoicouiu. Her status as a whistleblower is defined by Ohio Vice Code 411352. The trial court, in its summary judgment ruling, properly concluded that Stoicouiu qualified for whistleblower status under the revised code. The trial court rejected the school board's argument that Stoicouiu did not qualify because it was her duty to report fraud and abuse and or because of self-reporting by the board. Once again, the trial court rejected the board's argument. So having found that she qualified under the whistleblower statute, the court then addressed the issue of retaliation. And the 3 elements were: 1, was she in a protected class? The court had just determined that she was as a whistleblower. 2, was there adverse employment action? Yes, there was. She was non-renewed. 3, was there a causal link between her non-renewal and her public reporting of the audit, or of the fraud and abuse of the audit? The court determined that having established a prima facie case, the burden then shifted to the school board to establish a legitimate, non-retaliatory reason for her termination or non-renewal. Here, the board claimed that the non-renewal was because of Stoicouiu's failure to detect the fraud and abuse of the superintendent and his personal assistant. However, the fraud and abuse was implemented 5 years before Stoicouiu ever became the treasurer. It was only during her term that was discovered because of a third-party whistleblower who contacted the treasurer's office.
Did the improper payments occur at any time while she was treasurer?
Yes, sir, they did. And what had happened is the superintendent has to sign off on his assistant's payroll records. 5 years before Stoicouiu became treasurer, the superintendent and the assistant got together, and the superintendent was allowing her to apply for overtime because she was not performing.
And none of that occurred while she was treasurer? That was all before the treasurer that fired her?
Some of it occurred while she was treasurer, but the documents that authorized her overtime occurred before Stoicouiu was treasurer.
Understood, thank you.
And indeed, in the record, Stoicouiu had approached the superintendent and said, what's the effect? You know, your assistant seemed to have a lot of overtime, and his response was, that has been authorized by Human Resources. So it was a further misleading statement. In any event, she ultimately uncovered it by virtue of other whistleblowers that provide information to her, and that's in the record. So, before Stoicouiu ever reported this fraud and abuse. She had an impeccable work record. She's the one that discovered it. She's the one that publicly reported it. When she publicly reported it, the president of the school board criticized her, told her she would have not reported it to the state auditor. Part of the findings involved improper gifts to board members, including the president of the board, and that is in the record. Within 120 days, she is non-renewed and loses her job. The superintendent and the assistant are retained and get raises. Stoicouiu presented credible evidence to rebut any claim by the board that they had a legitimate, non-retaliatory reason. Stoicouiu presented evidence that their reasoning was pretextual and illegitimate.
And Counselor, just now reaching into that 5 minutes, you can sort of keep going whenever you want.
Here, the trial court erred. The trial court weighed the evidence and found in favor of the school board. This court has said many, many, many times the trial court on summary judgment cannot weigh the evidence that is left to the prior fact. In this case, all the evidence was to be construed most favorably to Stoicouiu. It's undisputed that there are disputed issues of fact that need to be resolved by the prior fact. For the trial court to conclude as a matter of law that the school board offered a legitimate, non-retaliatory reason flies in the face of summary judgment procedural application. This is a de novo review. This court can look at the entire record, and I submit to this court that there are issues of fact as to whether or not the board had a legitimate, non-retaliatory reason to terminate Stoicouiu in light of the factual predicate that led to a termination. I'm going to ask that this court reverse it and remand it to the trial court for a full trial of the matter. Thank you.
Thank you, Counselor.
Can you please the court? Your Honors, Counsel, good morning. My name is Stephanie Oliveira-Medica on behalf of the appellee, the Stow-Munroe Falls City School District Board of Education. The board respectfully requests that this court affirm the order and judgment of the trial court with regard to the board's motion for summary judgment and Ms. Stoicouiu's motion to strike, and find that both of the assignments of errors raised by the appellant in this case be denied. With regard to the first assignment of error, as an initial matter, Ms. Stoicouiu's counsel has applied the incorrect standard of review, a de novo standard of review. It is well established, however, that in an appeal from a motion to strike, the trial court's decision to deny a motion to strike will not be overturned on appeal, absent an abuse of discretion. That was held
Counsel,
Yes,
how
sir.
are they appealing a motion to strike?
The order of the trial court first addressed Ms. Stoicouiu's motion to strike. That was a fully briefed argument. There was a motion to strike filed by Ms. Stoicouiu's counsel with regard to the argument set forth by the board's reply brief. We subsequently opposed that motion to strike, and that was decided by the trial court prior to issuing its order relative to the board's motion for summary judgment.
But I guess what I'm asking is, but that issue of whether the board appropriately granted or denied the motion to strike is not on appeal, right? It's not part of their assignments of error.
Arguably it is, Your Honor, and that's how the board interpreted the appellant's first assignment of error. It is essentially arguing, Stoicouiu is essentially arguing that the trial court wrongly admitted evidence relative to the arguments set forth in the board's reply brief in support of its motion for summary judgment. And because it touches on an issue of the admissibility of evidence for purposes of deciding a motion for summary judgment, we believe that an abuse of discretion standard is appropriate.
Okay, let me just make sure I understand. So there's no requirement if somebody raises new issues in a motion, in a reply on summary judgment, in a motion for summary judgment and a reply. There's no requirement, is there, to file a motion to strike?
I'm sorry, can you repeat your question, Your Honor?
Is there a requirement that if the defending party raises on a summary judgment motion a new issue, the reason why summary judgment should be granted, is there a requirement that a motion to strike, and I should say the moving party, not the defending party, is there a requirement that the defending party on a motion for summary judgment files a motion to strike?
I'm not sure that there's a requirement that a motion to strike need to be filed. I think the important thing to keep in mind here is that a motion to strike was in fact filed, and that a brief in opposition was submitted, and that the court reviewed and considered the arguments set forth by both parties relative to the arguments made in the board's reply brief before deciding on the motion to strike, which is very different than the case relied upon in Ms. Stoicouiu's appellate brief. In the case of Smith v. Ray Esser, which is the case that the appellant relies on for purposes of its appellate brief as well as its reply brief, is very distinguishable than the facts in this case. In that case, there's a totally different standard applied in the reply brief based on a decision that came out subsequent to the brief in opposition being filed. And additionally, in that case, the plaintiff had not filed a motion to strike before the trial court ruled on the motion for summary judgment. Here again, Ms. Stoicouiu filed a motion to strike, the board opposed that motion to strike, and there was an order by the trial court. Regardless of the standard of review, on the first assignment of error, Ms. Stoicouiu cannot establish error regardless of the standard that's applied, because the board's reply brief was limited to the arguments made both in its motion and in response to the arguments set forth in Ms.
In the board's motion for summary judgment, did they raise the issue of retaliatory conduct regarding this count?
Yes, Your Honor. At record 53, pages 18 through 22, there were several arguments made. There was arguments made by the board relative to the fact that Ms. Stoicouiu was not entitled to whistleblower protection. There was a discussion relative to the fact that there was no causal link, and there was an argument made relative to the fact that there was a legitimate non-retaliatory reason based on the performance issues relative to those financial irregularities.
So what was in, and to follow up Judge Stevenson's question, what was given as the legitimate non-discriminatory reason as to why her contract was non-renewed? Not in the reply, but in the initial motion for summary judgment.
Yes, Your Honor. In the reply,
I asked for you.
I'm sorry, in the motion, I apologize.
That's okay.
Of record 53, pages 18 through 22. So for purposes of the legitimate non-retaliatory reason, it was the non-renewal was based on the deficient performance issues relative to the untimely recognition of those, alleged irregularities, financial irregularities that, as treasurer, Ms. Stoicouiu was required to prevent. It's also important.
Counsel, I have that motion in front of me, and I'm guessing you're starting at the bottom of page 18, when you say 18 to 22. It says that she can't establish under Ohio's whistleblower. It talks about how she can't be a whistleblower.
Correct.
which the trial court found that she was. And I understand your client's argument that that was error, but whatever it was, we're already to where the trial court has found that she qualifies as a whistleblower. And if the law doesn't permit her to be one, when she's performing job duties, is the argument all the way up to page 23. What I really don't see is non-discriminatory, non-retaliatory reason on those pages. And now I'm not saying that.
Your Honor, if I could,
go ahead.
I apologize. If I could direct you to page 22, and I don't have a copy of the brief in front of me. There's a middle section there on page 22 that discusses her performance issues and how those were considered in light of, that the non-renewal was considered in light of those performance issues, namely the untimely findings relative to the financial irregularities.
Okay. And part of this sometimes is the record number page and the numbered page of the document. So thank you for answering my question.
Absolutely. It's also important to note, based on the abuse of discretion standard, that it includes a component of Ms. Stoicouiu being materially prejudiced, which is not the case here. In fact, Ms. Stoicouiu's second assignment of error to this court concedes that in her brief in opposition, she included all alleged evidence to support her argument that the board's non-renewal was pretextual.
I want to make sure I understand too. I thought we were getting past the motion to strike because you just said it wasn't an abuse of discretion. And the only way we would be looking at an abuse of discretion standard review would be on the motion to strike. When we're dealing with a motion for summary judgment, we're doing de novo.
That's correct, Your Honor.
Okay.
That's correct.
Okay.
I was just finishing up with regard to the first assignment of error.
Okay, with the motion to strike, I thought you had moved on
Correct.
past the motion to strike, saying even if it didn't matter, that you had raised the issue of whether or not there was legitimate non-discriminatory reasons.
Right, correct, because Your Honor, the point is with regard to the arguments set forth in the reply brief by the board, that those issues were discussed. That even Ms. Stoicouiu's brief in opposition discusses pretext explicitly. So it would have been appropriate for the board to make the arguments that it did in its reply brief. And moving on to the second assignment of error, again, the trial court did find that the board articulated a legitimate non-retaliatory or non-discriminatory reason for the non-renewal of Ms. Stoicouiu's contract.
Did the trial court address the argument that this was all pretextual in any way in its decision?
Not explicitly, Your Honor. I think that ultimately,
Is that an element the court has to decide when they're deciding retaliatory conduct if it was pretextual?
Yes, Your Honor, and presumably the trial court did address that, did consider that while
But
it
didn't include it in its order, I guess, from what you're saying.
Correct, correct. But because those arguments were set forth in the briefing, I think it's appropriate to discern that the court did consider the pretextual arguments raised by Ms. Stoicouiu and addressed by the board. So once the plaintiff establishes the prima facie case, the burden shifted back to the board to articulate the legitimate non-retaliatory reason, which the board did. Ms. Stoicouiu's performance issues, namely her failure to detect and address the significant financial irregularities. And namely, Ms. Stoicouiu's contract was renewed pursuant to her contract, which was governed by revised code 3313.22. She was provided the proper notice of intention to not renew her by March 1st. In fact, she was non-renewed on February 25th of 2019. At that point, the burden shifted back to Ms. Stoicouiu to establish pretext. That can be done one of three ways: showing that the reason had no basis in fact, showing that the reason did not actually motivate the action, or showing that the reason was insufficient to motivate the action. And in doing so, Ms. Stoicouiu's counsel attempts to do so by kind of three buckets. First, by discussing discipline, arguing that others, including the superintendent and his assistant, were not disciplined. I think it's important to note that Ms. Stoicouiu was not disciplined. Her contract was simply not renewed. The superintendent's contract was simply not up for renewal or non-renewal at the time that Ms. Stoicouiu's contract was being non-renewed. It's important to keep in mind also that based on the state auditor's findings, there was findings of recovery, and both the superintendent and Ms. Padula, the assistant to the superintendent, were required to make those repayments to the state. Also important to keep in mind that per her contract, she was not required to receive any type of written reprimand or any performance improvement plan prior to any non-renewal. The second bucket is evaluation. Paragraph 14 of her contract discusses evaluation, and it reads that the board shall annually evaluate Ms. Stoicouiu by conducting no less than one executive session at either a regular or special meeting to, this is important, for the express purpose of discussing Ms. Stoicouiu's discussing Ms. Stoicouiu's performance as treasurer prior to any action by the board as to a subsequent term of the contract. Nothing per contract requires that she actually receive either an oral or written evaluation. Ms. Stoicouiu actually concedes that in her deposition. Also, she was evaluated. That was undisputed. She was evaluated during a special meeting on January 16th of 2019. She was also evaluated on February 25th, 2019, before the non-renewal actually happened. On January 16th, the record establishes that she was asked a series of questions regarding her performance and lack of controls in the treasurer's office. And on February 25th, several board members testified that they discussed her performance prior to the non-renewal. This is all consistent with the fact that her contract requires an evaluation prior to an action being taken. So there was evaluation completed before the board made a decision to non-renew her contract. Moving on to the non-renewal, that was also in line with statute. There was it was a non-renewal based on the fact that it occurred in the year of the expiration of her contract. The board can either re-employ or gives the treasurer written notice of the intention to non-renew before March 1st. Ms. Stoicouiu also importantly conceded that she was not required to receive any notice regarding the board considering her performance or non-renewal. She was only required to receive the notice of the non-renewal subsequent to that. And further, nothing requires that she be in attendance at any discussion relative to her evaluation or performance. I do want to touch on the fact that while the trial court found that Ms. Stoicouiu was entitled to the protections under the whistleblower statute, it is the board's position that that was an inaccurate finding by the trial court. And that is because we do not believe that Ms. Stoicouiu was able to establish either the first or third elements of a prima facie case of whistleblower protection. At its core, Revised Code 4113.52, which is Ohio's whistleblower statute, requires both an oral and written report to the employer. And then if the employer does not correct the violation or make a reasonable and good faith effort to correct the violation within 24 hours of the oral notification or receipt of the written report, they can report to other agencies. The chronology here is important.
Counsel, it's unfortunate, but I have to let you know that you've utilized your 15 minutes for today's oral argument.
Okay, thank you, Your Honors. Thank you.
Thank you very much.
The issue of the motion to strike was raised in our briefs, and I'll rely upon our briefs. However, since this panel sits in a de-novo capacity on the summary judgment issue, this panel can review all the evidence that was presented by either party throughout the proceedings and deciding whether summary judgment was appropriate. What was lacking in the appellee's argument here today was any discussion of the summary judgment standard, which is the very reason why we're here today. The trial court cannot weigh the evidence and resolve disputed factual issues on summary judgment. The disputed issue is whether or not the reason offered by the school board to Ms. Stoicouiu's termination or non-renewal was contestable or illegitimate. That is a factual inquiry that has to be resolved by the trier of fact. I would ask that the court reverse, remand from trial on the merits. I have 1 minute left. I'll answer any questions you have.
Seeing none.
Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision in due course, which will be sent to all parties to this appeal as well as posted on our website. Thank you both.
Thank you.